Okay, so talk to us about the common distribution methods.
So typically when we're talking about distribution, we're talking about one of two ways to get stuff to your beneficiaries. And so we're either talking about a per capita distribution or a per stirpes distribution. And so what per capita means is it's by the head. So the best way to do it is just to look at an example, because it's far easier to deal with examples. So you've got Andy, and he has two children. He's got Betty and Charles are his kids. And then in addition, Betty has two children. So Andy's grandchildren, David and Greg. And so what happens in this deal is that before Andy passes away, Betty predeceases him. Okay? So when Andy passes away, under a per capita distribution scheme, since Charles is still living and we're going to take at that level of the kids, David and Greg step up to take over their mom, Betty's interests. And so now essentially you have David, Greg, and Charles, and on a per capita distribution scheme, they're going to be treated as the same. Okay. So Charles, David, and Greg are all going to end up with a third of Andy's estate.
Okay.
So per stirpes works a little bit differently. It's by the roots of the family tree. And so what we do here is we still have Andy with the two kids, Betty and Charles, and Betty has the two kids, David and Greg, who are Andy's grandsons. And so Betty again predeceases Andy. So when Andy passes away, what we're going to do with his shares is, because he had the two kids and one of the kids is still living, we're going to divide his estate into two halves. So Charles is going to inherit half of Andy's estate. Now Betty's side of the family is also going to inherit half. So when David and Greg inherit, they're going to get a quarter each of Andy's estate. So the net effect is Charles ends up with a half and David and Greg end up with a fourth. And so that's basically how per capita and per stirpes work. My advice to you as CFPs is, when you start worrying about distribution schemes of per capita and per stirpes, this is one of those points in time where you pull out the Rolodex and make the phone call.
Right, absolutely.
This is important to know, though, because like I said before when we talked about beneficiary designations, oftentimes it's unclear about whether beneficiary designations are per capita or per stirpes. Often you'll have a little box that you can check on the beneficiary designation form about which method you want to use. And so one of your key roles is, when you're helping the client and the attorney fill out those beneficiary designation forms, you need to make sure that the per stirpes or per capita is checked, that it doesn't go unchecked, because that's going to leave kind of this open-ended room for interpretation. So help the client, help the estate planning attorney.
Absolutely, absolutely. Well, now, I feel silly asking this question, but can wills be changed or amended or revoked?
You'd be surprised about how many people think that once you've done a will, you can never change your mind. But the truth is, you can always change your mind. As long as you're living, a will can be revoked, amended, changed, whatever you want it to be. So typically when you're looking at amending a will or changing the will, you're either going to do one of two things. You're either going to do a brand new will, just start over from scratch, which is going to revoke the earlier will and replace it with the new will. Or you're going to do an amendment to the will, which is called a codicil. So a codicil, we generally use those when we just have maybe one or two things that need to be changed in a will. If it's kind of a wholesale rewrite of the will, then we'll just do a brand new will. So an example of a codicil might be that say that I named 3 potential executors in order in a will, and one of those executors passes away. Well, then I might do a codicil to the will just to change who the choice of executor is, to name somebody else to replace the deceased person. So revocation is when you get rid of the will completely. And so there are a lot of ways that you can revoke a will. You can do it in writing. You can just say, I revoke my will. There's also, you could cut your will in half, which acts as a revocation of the will. At least it does in most states. There are some what they call overt acts that you can take to act as a revocation of the will. Probably the primary one is cutting a will up. Actually, I have a funny story about this. I had this client whose husband had been an attorney, and she had wills that her husband had drafted for her, and she outlived her husband by a little more than 30 years. But she was a nice lady that I knew from some community activities, and she would come by and have coffee with me every once in a while. So one day she called me up and she says, "Hey, Chris, you know, that will that John wrote for me is really old. It's, 25 years old. And so what I'd like you to do is I'd like you to look at the will to see if it's still valid." I said, "Great. Aren't you coming to have coffee with me on Friday morning?" She said, "Yeah, I'm coming, but I'm not feeling so good, so let's kind of wait and see." So Friday morning she calls me up and she says, I'm not going to come and have coffee with you. I'm not feeling good. I think I've got a sinus infection, but I'm kind of worried about this will thing. And so what I want to do is I want to fax you my will, and you can take a look at it. So she faxed me her will, but it came out looking real funny. It was like half a page on each page of the fax. But I didn't really think much about it. I just wasn't kind of modern technology. I just didn't think about it. And so I start flipping through the will, and I look at it. The will's fine. It meets all the still Texas legal requirements.
Right.
There's not necessarily a reason to change the will. And so I called her up and I said, hey Clara, I looked over your will and, looks fine. Are you wanting to change any of the executor appointments? She said, no. I said, do you still want it to go to all the kids equally? Yeah, I still want it to do that. Okay, well, it looks good. It looks perfectly fine. I know it's old, but, unless you just want to update it, there's not really a legal reason that you have to. And she says, okay, that's awesome. And I said, well, the one thing that I had questions about is it came out looking really funny on my fax machine because it was like a half page at a time. And she goes, oh, well, honey, that was on legal paper, and my fax machine at the house won't take legal paper. And I was like, okay, well, why did it come out a half sheet at a time? She goes, well, Chris, I just cut that thing in half so I could fax each half a page to you. And I said, well, Clara, I changed all my legal opinions. You totally need a new will. Because when you cut that bad boy in half,
it's done.
You revoked your will,
Right.
So we need to do a new one for you. So I had to drop everything that day because it made her super nervous, because she was elderly, and so I had to drop everything and do her new will right that day, and we ended up going out to the house and executing it for her so that she would have peace of mind. But so the funny thing about overt acts is sometimes the overt acts aren't even intentional acts, but they still act as a revocation of the will.
Wow.
There's even some old Texas law that says that unstapling a stapled will is an overt act such that it revokes the will.
Wow.
Yep. So don't unstaple, don't mess with your originals, and no matter what you do, don't cut them in half and fax them. That's the answer.
Yeah, that would. Well, just throwing one other idea out there, and this is sort of as a CFP to clients. You tell your clients if they have any major life changes or if they haven't had their will reviewed in 10, 15 years, it's probably a good idea to have that will reviewed on a semi-regular basis. What time frame do you suggest that people have their wills reviewed?
No matter what form of estate planning that you have, even though we'd like to think of it as being lifetime planning, the truth is that things change.
Right.
Right? The probate code changes, the Texas legislature changes its mind, the IRS gets flaky. During the 18 years that I've practiced law, the amount of the estate tax exemption, I think, has changed 9 times.
Right.
So 9 times in 18 years. I'm not the greatest math student in the world, but that's every other year of my law practice. So it is not something that you do once and you stick in a drawer and you never look at again for the next 30 years. Things change. Things don't just change on the law side. Things change in your personal life.
Exactly.
You get divorced. One of your kids gets divorced. Somebody that you name as executor passes away. Someone that you name as guardian for your kids gets a little too old to effectively be guardian. One example of that is when we first did our estate planning when my kids were just born. When my daughter Bethany, who's now 15, when she was first born, we did everything so that we set up who the guardians would be. And at that time, we named my parents as the guardians for the kids. Well, now Bethany's 15. We have a little boy who turned 13 today, and then my wife and I, in 2 weeks, are adopting an 8-year-old. The 8-year-old in particular is a very active child, and my parents are not as young as they once were.
Right.
Life circumstances for them have changed because my dad is, he's a professor at A&M and he's gone into semi-retirement. And so they really are not anymore in the position to raise an 8-year-old. Now, the other thing that's happened since that time is my sister's gotten married. She has a 3-year-old. Now she and her husband, who have been married now about 10 years, are in a much better position than she was as a single woman to raise the kids. And so, we went back and changed it. And so that Katie and Jesse would be the guardians for the kids instead of my parents. So those are the kinds of things that just naturally happen.
Right.
So I like to think of estate plans as being 3 to 5 year plans. So what you should look at doing is plan for about 5 years out, and then you should review those plans at least every 5 years. And during that time, that may not mean that you change anything. It may not mean that a single document needs to be amended or revoked. It just means that you need to look at it with your clients, and you need to kind of think through it with your clients. And most estate planning attorneys that you'll deal with, they will do consultations with their clients to talk about changes in the law or changes in their family and life circumstances. And usually they'll do those for a reduced fee or no fee, and only charge for whatever needs to be changed. And so in our office, we do free consultations for people that we've written plans for.
That's a good thing to know up front, by the way.
Yeah, and we'll do those as often as they want to. So we've got some clients that'll come in pretty much every year. We have some clients that we have to drag kicking and screaming into our office, but we occasionally do that as well. The nice thing about working in conjunction with a financial planner is that you guys are pretty much doing annual reviews, sometimes quarterly reviews, and so you are in the best position of anyone to remind your client that their estate plan is a 3 to 5 year plan document, and you can make it part of your annual review to say, okay, your will was drafted in 2007. When's the last time you talked to your attorney about it? When's the last time you went in for a consultation? And a lot of attorneys that are in more of a team approach, they'll do those consultations in consultation with you.
Right.
They'll have you in the room. So you could make your every 3-year annual review be a review that is not just you, but is also the attorney in the room. And you guys could bring him in, talk about the estate plan portion of it, and then let him leave and talk about the portfolio allocation portion of it. And so that is, again, one of those, much like the beneficiary designation issue, that is one of those things that you can be a constant trusted advisor to your client, and that's one of the best services that you can provide to them.